of a lawyer. In studying the subject of legal counseling, the lawyer's workload cannot be excluded from the discussion. The omission or inclusion of such would spell a difference in the success or failure of law practice. Law practice may be classified into the following tasks undertaken by a lawyer in the pursuit of his profession. First is advice. Second is negotiation and conciliation. Third is drafting pleadings, documents, and contracts. Fourth is litigation. Fifth is financing. Sixth is property management. Seventh is acting as executor, trustee, or special administrator. And lastly, specialization. Giving advice. Giving advice is the task lawyers most commonly perform, and whatever else they do for clients is almost invariably accompanied by advice. In the field of advice, every lawyer is presumed to be competent in giving spontaneous and often advice to prospective clients during the first interview, at least on a foreshadowing and relative outcome of potential litigation. But if there is even a glimmering hope of pursuing further negotiations and compromises, this process should be pursued relentlessly and exhaustively before giving up. In layman's language, better a bad settlement than a good litigation, with all the attendant anxiety, mental torture, recurrent stress, and sleepless nights. However, in matters involving an intricate question of law and the latest ruling of the Supreme Court, the lawyer should be frank with the client that the same cannot be answered on the spot, hence needs a reservation on your part to make prior research with verification with the recent applicable jurisprudence and statute from textbooks of renowned authors, the SCRA, Philippine Reports, Official Gazette, and latest Supreme Court reports. The following are the considerations in giving advice. First is anticipated reactions of courts and other administrative agencies or official or quasi-judicial bodies. Second is probative value of evidence. Third is desires and resources of clients and other affected parties. And lastly, alternative courses of action. The following are the alternative courses of action that the lawyer may suggest to his client. He may pursue any or all of them. First is indicate the preference as to which course of action should be pursued by the client. Second, proceed to argue persuasively as to why the client should adopt this course of action. And third, he may try to avoid showing any preference at all on which course of action should be taken, merely posing available alternatives in as neutral terms as possible. The lawyer merely restricts his role to illuminating choices, not recommending them. Any opinion he expresses is directed only at the relevancy and merits of the alternatives, not at deciding among them. The role of the lawyer is to assist the client in deciding. Hence, he has no power to force him to do. Non-legal advice. Lawyers are asked to give advice having little or nothing to do with legal doctrine or lawmaking or adjudicating bodies. Lawyers holding positions in government and business are often trusted counselors on a wide range of family, business, administrative, and political problems. As long as the performance of these acts do not prejudice the interests of public or are done outside of office hours, there is nothing wrong in the acts of government lawyers who earn extra income outside of official functions. These include full-time judges and government prosecutors who teaches in law schools outside of office hours. Role conflict in giving advice. In advising clients, the lawyer can often run into conflict giving rise to the following questions. First, when should the lawyer be the client's servant and when his critic? Second, to what extent should he identify with the client's goals and follow his expressed wishes? And lastly, to what extent should he question them? Most of the answers to these questions focus on what client wants. Client may want its lawyer to be a neutral evaluator of client ideas, or may just want approval of his ideas. reassurance to bolster his morale, or a sounding board, or an authority to strengthen his hand on the bargaining table with potential adversaries. The lawyer's ultimate word. The best approach in dealing with this particular client is to define, right upon the acceptance of the employment, or before giving any advice, the extent of the client's role. He should be impressed that as a lawyer, his wishes can be followed so far as they appear to be legally feasible and do not collide with the lawyer's oath. Essential factors in negotiation and conciliation. The most common task a lawyer encounters in his daily practice is dealing with another or potential adversary to reach an accord between the client and the other party. These factors may consist in the following. One is proposals to the other side. Second is counter proposals. Third is reconsiderations. Fourth is compromise. Fifth is advice to clients. And lastly, client instructions to counsel. Usually, there are only two parties that are involved in a negotiation, and most often, all exchanges between two sides handled but by two persons, one on each side, with one or both of these persons frequently being lawyers. But negotiations may involve more than two sides or parties, and negotiation efforts for any side may be made by a team or persons the client, his lawyer, are a common team.
Negotiation and conciliation. In advising clients, the lawyer can often run into role conflict, giving rise to the following questions. First, when should the lawyer be the client's servant and when his critic? Second, to what extent should he identify with the client's goals and follow his expressed wishes? Third, to what extent should he question them? Most of the answers to this question focus on what the client wants. He may want the lawyer to be a sounding board, a neutral evaluator of client ideas, or he may just want approval for his ideas, the assurance to bolster his morale, or perhaps respectable authority to strengthen his hand on the bargaining table with potential adversaries. The common task a lawyer encounters in his daily practice is the dealing with another or potential adversary in an effort to reach an accord between the client and the other party. These factors may consist in proposals to the other side, counter proposals, reconsideration, compromise, advice to clients, and client instruction to counsel. Usually, there are only two parties that are involved in a negotiation, and most often all exchanges between two sides handled by but two persons, one on each side, with one or both of these persons frequently being lawyers. But negotiations may involve more than two sides or parties, and negotiation efforts for any side may be made by a team of persons. The client and his lawyer are a common team. One important thing to remember when negotiating for a client is that the lawyer must be equipped with the special power of attorney before sitting at the negotiating table. The principle is that a general power of attorney does not include special power to perform a particular act. The performance of the acts without the consent of the client does not ipso facto render the transaction or deed void, but only voidable until ratified by the client. The need for such special authority is indispensable, especially for a lawyer who appears for his client in a court proceedings, so that in case the parties have reached an amicable settlement, which is allowable during any stage of the proceeding, as long as the judgment has not yet become final and executory, as in a judgment based on a compromise agreement. Judgment on the pleadings or confessions of judgment could be rendered by the court. But without such special authority from the client, the judgment of the court based on the compromise agreement cannot be enforced, it being null and void, unless ratified thereafter, but before the finality of the decision.
Another workload of which the practicing lawyer is constantly kept busy and cannot persevere without is the drafting and writing and revision of written instruments. A practicing lawyer may be called upon to draft many kinds of instruments, including originally phrased documents tailored to a single transaction or series of transactions and standard forms adaptable to various transactions. The following are typical of such instruments creating legal rights and non-legal matters that occupy the day-to-day activities of the practicing lawyer, as well as constitute as lucrative sources of his lifeblood, to wit, number one, usual contracts and deeds, sales, leases, mortgages, wills, partnership agreement, articles of incorporation, pleadings, compromise agreements, decisions and resolutions, press releases, letters of demand, and various kinds of written communication, staff memoranda, advertisements, special power of attorney, petitions and motions to be filed in appellate, appeal briefs, appeal memoranda, letters of administration, letters rogatory, and letters of publication. Documents of these kinds may relate to some crisis involving the client's legal rights, and it is felt that these rights will be best protected if the lawyer himself does the drafting. But sometimes the lawyer is called on to draft such documents merely because he writes well. Clarity and precision writing. The ability to write with clarity and precision and to anticipate all relevant legal and factual considerations is a lawyer's skill of high order. Some lawyers consider this their major skill, and with a craftsman's sense of pride and creative mastery, draft documents carefully shaped to their clients' individual needs. Drafting is so time consuming that some highly paid lawyers even turn it over to their less paid juniors. The need for expensive research work in well equipped libraries like the Supreme Court and Court of Appeals becomes a compelling necessity in the area of drafting. For routine drafting of court pleadings and customary deeds, the use of legal forms of reputed authors will suffice without having to entail the trouble and expense of coming to Manila in the case of small town practitioners. This is the reason why the subject of legal forms and legal writing have been incorporated into the model law curriculum in order to train the not so gifted lawyer to be in the art of drafting of legal and non legal documents. Gifted drafter not required. One does not need to be a gifted writer to be able to draft a nearly perfect document. Even in the drafting of a will, which involves highly technical and precise legal terms to convey the real wishes of the testator, should not be accomplished with much difficulty as long as it contains the essential requisites and formalities provided by law. The simpler the language is used, the better, and with much facility can the will be probated than with high sounding and obscure language which often confuse the courts and the implementers of the will other than holographic will. The better practice is to keep sets of legal and non-legal forms in your private files consisting of carbon or Xerox copies of samples of instruments developed by the lawyer of his firm in past transactions. For added convenience so as to avoid delay, especially when the lawyer is running against time, is to compile these sample copies into loose leaf volumes or in a separate cabinet duly marked in chronological order within reach, so that when the need arises, you don't have to grope or cram for them, especially when you are preparing for trial. Litigation is the last and crucial aspect in the lawyer's workload. When, despite all avenues and pressure packed attempts at conciliation and negotiation by the practicing lawyer have failed, there can be no more alternatives left to protect the rights and interests of your clients except to go to court. The term litigation is frequently used to refer only to proceedings before courts. Here it means proceedings before any tribunal, whether judicial or quasi judicial or administrative body, vested with jurisdiction to decide issues involving parties who are entitled to appear before the decision maker and prosecute their cause. Litigation and negotiation distinguished. In litigation, a third party decides issues involving others, whereas in negotiation, parties with conflicting interests seek to resolve or accommodate to them by mutual agreement among themselves. The lawyer's task in litigation varies greatly depending on whether the proceedings are contested or uncontested. A case is contested as long as each side seriously threatens to oppose the other before the decision making tribunal. It ordinarily is uncontested if the defendant default or fail to appear. How to proceed effectively in uncontested annulment suits? If a lawyer wants to end the litigation very quickly in an annulment of marriage suit, all that the parties have got to do is to arrange through their counsels for an uncontested litigation. This is achieved by an out of court understanding that the defendant should not answer the complaint, from which the court may proceed to calendar the case for hearing, during which the defendant does not appear. Upon proof of service of notice to the defendant, complainant can then move for reception of his or her evidence ex parte, which will serve as basis for the court's decision granting annulment. Of course, this practice may appear unethical, bordering on collusion, which the law abhors. There is an extra legal dimension involved in this kind of practice, which needs exercise of subtle tact and diplomacy with the public prosecutor not to interpose objection and to make a favorable written recommendation of manifestation to be submitted to the court that the situation of the parties is beyond reconciliation. But the quickest remedy is to persuade the prosecuting attorney not to appear in court anymore. And upon proof of service of notice to the prosecutor, counsel for the defendant may now move for the dismissal of the complaint for lack of interest on the part of complainant. The foregoing proceedings and remedies can be realized only with the court's approval upon compliance with Article 58 of the Civil Code, which provides that an action for legal separation shall in no case be tried before 6 months shall have elapsed since the filing of the petition. This provision likewise applies to annulment suits or petitions for the declaration of absolute nullity of marriage. Recommended shortcuts to non-contested suits. Insofar as criminal cases are concerned, a recommended shortcut remedy is to enter a plea of guilty when the imposable penalty for the offense charged does not exceed prisión correccional or not exceeding 6 years, in which case the convict can avail of the benefits of the probation law at once upon promulgation of the decision in open court. If the accused is on bail, he can avail of his bail bond for his immediate release or apply for a recognizance by any responsible person in the community who can guarantee his appearance whenever the court requires his personal appearance. And the offended party does not interpose objection pending the evaluation and approval of his application for probation by the court. While it is true that success in contested cases help build a good reputation for a trial lawyer, yet much contested litigations are poorly paid, considering the element of time that must be spent in preparation, preliminary court appearances, waiting for trial, and the actual trial. In exceptional cases, for the purpose of accommodating the best paying clients, trial work is emotionally stressful, and many lawyers dislike it for this reason. In negotiating for a client in a strong bargaining position, the lawyer should calculate the risk to client reputation of striking a hard bargain. In advising a creditor on remedies against defaulting debtors, he should consider the danger that some remedies may make the client appear mercenary and ruthless. Shaping and guarding his client's reputation may be part of the lawyer's job in most any kind of law practice.
Good evening, everyone. I am going to discuss about property management and leasing. Real estate continues to be one of the best places to put money. Property values rise on an annual basis, and they can also generate passive income by converting them into rental homes and commercial buildings. Real estate is not affected by inflation because its value rises year after year. It's no surprise that property owners want to build a green living development on their property. Also, one of the reasons is to generate consistent income. Many property owners develop their lands into apartments, townhouses, and commercial buildings. The difficulty with having rental property is managing them, and this is where property management services in the Philippines comes into play. So there are two questions here. How can a Philippine property management company assist you in managing your real estate property? And is there a need for a lawyer in managing your real estate properties? So first and foremost, how does property management dispute process work? What is property management in general? The oversight of real estate by a third party, and the types of property included therein are residential, commercial, industrial, and property for special purposes. Depending on the territory or the jurisdiction, most property must follow the provisions of the state's property management law. In our case, it's the Philippine laws. However, the majority of the property management disputes follows a similar pattern. First and foremost, property owners must adhere to the regulations and requirements enacted in the respective places. Landowners are usually required to follow any laws and that a landlord does, and vice versa with the tenants. And once the property landowner is confident that they have followed all applicable laws, they should consult the tenant's lease agreement. And if there is a lease agreement, however, it does not provide adequate answers, the property landowner or the manager should attempt to resolve the issue with the tenant by calmly discussing the situation with them. And they should strive to maintain a professional demeanor and maintain written records on all communications with tenants. The question, do I need a lawyer for a property management dispute? The answer is yes. Whether or not you are a tenant or a property landowner involved in a property dispute, there are reasons why you need a lawyer for such dispute. Here are the reasons why. 1. It is for the client's best interest. It is the landowner's best interest to seek legal counsel from a local lawyer, and a lawyer who has handled property management dispute will be familiar with the laws and will be able to walk through the proper steps to resolve your property management issues. The lawyer can also help you determine whether you have a viable claim, and if so, he can prepare your case. Alternatively, if you are a property landowner, the lawyer can conduct a legal search for potential defenses and devise a strong defensive strategy. In addition, the lawyer can represent you in court as well as during mediation or arbitration. But for the best interest, since vast majority of the property management lawsuits are based on negligence claims, people would tend to want to consult with their lawyer about negligence defenses and gather any evidence that will disprove the tenant's claim or prove the tenant's contribution to the problem. It's important to keep in mind that our jurisdiction will deal with such dispute based on the merits of the case. So what are the other work tasks included? These are also common property management dispute. One, we have leasing, eviction, contract for repairs, rent collection. And generally speaking, the property landowners tend to profits over tenant satisfaction, and thus there is no surprise that these landowners are often at the center of many property disputes, as well as when the tenants refuses to vacate the property when the lease or the contract has already terminated. One, we have eviction. Eviction issues are one of the main causes of property management disputes, and these are disputes over an eviction may involve procedural issues that may make the eviction action illegal. For example, improper notice or self-help problems when the landlord changes the locks or removing a tenant's personal property without their consent and placing it on a curb. We also have maintenance problems. This is the example for contract for repairs and rent collection. Maintenance problems may refer to actions such as failure to maintain the premises, failure to respond to maintenance requests quickly and thoroughly, or simply ignore a tenant's maintenance issue entirely. Also, these are other tasks included: arranging for maintenance services and insurance, payment of taxes and other expenses of the clients, acting as executors and trustees. In addition, we also have housing violation, for example, not providing heat or water to tenants in the vicinity, and which may be grounds for any liability in other violation for housing code. We also have miscellaneous issues which arise from property managed disputes, including failing to screen employees and suspicious rent collection practices. The last, will be discussed by the other reporters.
Allow me to present the effect of perfection of appeal under Rule 41, specifically Section 9 of the 1997 Rules of Civil Procedure versus the old interim law. In Section 9, Rule 41 of the 1997 Rules of Civil Procedure, there is a uniform procedure rule providing the same effect in terms of the perfection of an appeal. While under the old interim law, the trial court loses jurisdiction over the entire case. Number one, upon perfection of the appeal by filing a notice of appeal or upon expiration of the last day to appeal by any party and upon approval of the record on appeal. On the other hand, under Section 9, Rule 41 of the 1997 Rules of Civil Procedure provide otherwise, that as long as the appeal was filed in due time with reglementary period to appeal, the court of origin cannot be deprived of its power to exercise jurisdiction over matters in the exercise of its residual jurisdiction for the preservation and protection of the rights of the parties involved. In the case of Fortune Life and General Insurance Company Incorporation versus Court of Appeals, it actually cited three instances to exercise residual jurisdiction. The first one is to issue orders for the prosecution and preservation of the rights of the parties which do not involve any matter litigated by the appeal. Second, to approve compromises offered by the parties prior to the transmittal of the record on appeal to the appellate court. Third is to permit the prosecution of pauper's appeal. In the case at bar, the action for damages is an act of vindication, not an act to protect and preserve, but to punish, and making one pay damages.
Acting as executor or trustee. The client that was hired to draft the will, he will just as well appoint as executor because a lawyer possesses a vast knowledge of the law on wills and succession. He must be conservant about how much the portion of the estate he is permitted to dispose of by the will without encroaching on the legitimate of compulsory heirs. The lawyer's fees depends on how knowledgeable and effective he is in the employment of appropriate language in the making of a will, granting tremendous powers and benefits to the executor. As long as the executor does not betray the trust allowed by law unto his fiduciary responsibility, he will continue to enjoy the goodwill of his client and the courts. And to avoid any charge of maladministration, negligence, and or incompetence, the executor's remuneration must be specified in the will. So what is the reason behind this? First, there's no need to further briefing and extended and repetitious inquiry of matters. Second, it would be difficult to participate as acting executor if he did not participate in the drafting of such will. Third, he should precise the specific area and kind of property of the descendant's estate. And last, will is self-implementing even without a court's order. Specialization. It refers to the work task of a practicing lawyer who specializes or has vast expertise or is highly competent at performing a specific kind of work or practice. An example of specialized lawyers are corporate lawyer who specializes in dealing with legal problems involving corporations, and labor lawyer who specialize labor-related disputes such as employment contract, fulfillment of labor relations. General practitioner is a lawyer who engages in general practice of law incompatible with specialization. It is one who is willing to represent almost any kind of client in any kind of matter if the client will pay the practitioner's going rate. A general practitioner means that that attorney is not only focused on only one area of law. And it does not mean that he is not competent. It just means that that attorney is not focused only in one area of law. Example of this is a general practice of law. It's like a family doctor. Although a family doctor is not specialized in heart surgery, it does not mean that that family doctor is not competent. The same is true for lawyers. Although a general practice lawyer does not handle tax laws, it does not mean that they are not competent in the areas of law they handle. Lawyers are blacked out by conflict of interest from taking some legal matters which may cause impairment or violation of his oath bordering on ethical grounds. Almost all lawyers who are beginners in the practice of law or have just passed the bar examination cannot qualify for the word specialist. Actually, it all depends on the lawyer's attitude to take the risk and the hard work on the problems confronting him. In the provinces, none could be classified as specialist or general practitioner as long as the client's pursuit is capable of paying the fees agreed upon.